What if I told you the lawyer who mocked that black grandma in court had no idea he was standing across from the woman who wrote the very law he tried to twist? It started like every other zoning fight: slick suit, loud confidence, an old woman with a cane, and a courtroom that thought it already knew who mattered. But by the time the truth hit, the echo of her words would shake every corner of that marble hall. Stay till the end, because this isn't just about a courtroom. It's about how justice walks in quietly and leaves the room forever changed. The courtroom didn't know her name yet. They saw an old woman with steady hands and a quiet stare, someone easy to underestimate. Across the aisle, a young attorney grinned like the verdict was already his. But before this day was over, every smug word he spoke would come back to haunt him, because the grandma he mocked wasn't just fighting for her community, she built the law he was hiding behind. The gavel hit like a gunshot against marble. "Your Honor, this elderly woman clearly doesn't understand the law." Carter Reeves' voice cut through the courtroom like the blade it wanted to be. He stood there, 33, slick suit, slicker grin, glowing under the fluorescence that made everyone else look pale. Ruth Ellis didn't flinch. She sat at the plaintiff's table, hands folded neatly over a weathered leather notebook. The walnut cane rested against her leg, its polished handle glinting faintly each time the overhead lights flickered. Beside her, Maya Ellis half rose before forcing herself back down. The young attorney's pulse thudded so loudly she thought everyone could hear it. Her grandmother had warned her about men like this, voices full of authority and hollow in everything else. Carter circled the table like a shark smelling old blood. He plucked a few sheets from his portfolio and waved them theatrically in Ruth's direction. "With all due respect, ma'am," he said, tone coated in sugar and contempt, "someone of your background might not grasp the complexities of Ellis versus Ridgeland. Perhaps I should explain it in simpler terms." A ripple ran through the gallery. A juror's pen slipped from her hand and clattered against the table. Judge Naomi Carter's eyes narrowed just slightly, but she let the silence hang. Carter tilted his head toward the jury and rolled his eyes like he was performing for them. "The precedent is clear. Her little community center simply doesn't qualify for protection. Do you understand that much?" Maya's chair scraped back half an inch. "He's baiting the jury," she whispered. Ruth didn't look at her. "Let him," she murmured softly. "Loud men often do our work for us." When Carter gestured again, his cuff brushed Ruth's water glass and nearly knocked it over. The bailiff stepped forward. Judge Naomi's voice sliced through the tension. "Mr. Reeves, watch your proximity to the witness." Carter smirked, pretending not to hear. He straightened his tie, glanced toward his firm's row of associates, and flashed them a grin that said showtime. Ruth's fingers brushed the spine of her notebook, its corners softened by years of use. The faint hum of the ceiling lights filled the pause. She exhaled quietly through her nose, her expression unbothered. Maya wanted to shout something, to remind the court who this woman was, what she'd built, what she'd given. But Ruth's calm was its own rebuke. Every measured breath felt like a closing argument she didn't need to speak. "Let me put this in plain English," Carter continued, pacing in tight arcs around her. "Progress isn't sentimental. Your property stands in the way of growth. You can't cling to nostalgia and call it justice." The judge tapped her pen once. "Mr. Reeves, finish your statement or sit down." He held up both palms. "Of course, Your Honor, just making sure we're all on the same page." When he finally retreated, the echo of his footsteps seemed too loud in the room. Maya caught her grandmother's profile. Steady, dignified, eyes forward. No flinch, no fury, just calculation. And in that stillness, the real story began. That morning, hours earlier, sunlight had spilled across the steps of the Cook County Courthouse, turning the marble a pale gold. Ruth had stepped out of a modest gray sedan, her cane striking the stone rhythmically. Maya climbed out from the driver's side, balancing a briefcase and a thermos of coffee. "Are you sure about this, Grandma?" Maya asked. She tried to sound confident, but her voice betrayed her nerves. "We've prepared," Ruth said, adjusting her hat with practiced precision. "The law doesn't belong to those who speak the loudest." Maya smiled faintly, finishing the mantra they'd repeated through years of study and mock trials. "It belongs to the clearest record." Together they climbed the wide courthouse stairs. Attorneys in $1,000 suits brushed past without acknowledgement. Two paralegals, mid-laugh, turned to stare at Ruth's cane before whispering something to each other. Ruth didn't slow. A sleek black town car pulled up behind them. The driver opened the rear door and out stepped Carter Reeves, tailored, polished, practiced. His assistant followed, juggling two briefcases embossed with the logo of Northline Partners. "Morning, Ms. Ellis," the bailiff greeted Ruth as she entered the building. "Back again so soon?" Ruth's eyes warmed with recognition. "Old habits," she said with a small nod. Inside the pre-trial conference room, Carter was already holding court, laughing with another associate, charm dialed to maximum. He stopped mid-sentence when he noticed Ruth and Maya arranging their files. "Northline Partners, representing Northline Urban Ventures," he announced to the room, not to them. He extended his hand toward Maya while his gaze slid right past Ruth. "I don't believe we've met." "Maya Ellis, representing the South Shore Cultural Hub," she said firmly. "And this is my co-counsel, Ruth Ellis." Carter's brow arched. "Community Hub, huh? The old building on Halstead?" He chuckled to his colleague. "Should be quick and easy." "Mr. Reeves," Ruth began, "I'd like to review the zoning." "Let's save that for the courtroom," he interrupted smoothly. "Wouldn't want to spoil the suspense." The court clerk entered then, distributing case files. She offered Ruth a sympathetic smile. "Good morning, Ms. Ellis. Always a pleasure." Ruth returned the smile. "And you, Clara." Carter caught the exchange, confusion flickering across his face before he smothered it with indifference. By the time they entered courtroom 3C, every bench was occupied. The Northline team settled in with the confidence of a firm that expected to win before lunch. Ruth set her notebook beside the microphone and waited. "All rise for the Honorable Judge Naomi Carter," the bailiff announced. Naomi Carter's black robe swept as she ascended to the bench. Her gaze passed over the room, taking inventory. When it landed on Ruth, there was the briefest pause. Recognition, respect, but no words. Carter rose first, buttoning his jacket in one fluid motion. "Your Honor," he began, voice resonant and rehearsed. "Northline Urban Ventures represents progress and economic opportunity for this city. While we appreciate sentimental attachments to older buildings, we cannot allow nostalgia to stand in the way of development." He paced with deliberate control, turning to gesture at Ruth and Maya. "The plaintiffs would have you believe their outdated property deserves protection, but facts and law are clear. Growth must move forward." His tone filled the room. To some jurors, he sounded persuasive. To others, simply loud. When Maya stood to respond, her hands trembled slightly. "Your Honor, the South Shore Cultural Hub isn't just a building. It's living history, home to black-owned small businesses since 1953. It sheltered civil rights attorneys when few offices would lease to them. It's one of the last spaces in the district where community means more than profit." "Objection," Carter snapped. "Unsupported allegations about my client's practices." "I'm establishing context," Maya countered. "Your Honor, this is clearly—" "Mr. Reeves," Judge Naomi said, raising one hand. "Sit down. You'll have your turn." He exhaled loudly, like a man humoring a child. When Maya finished, the judge nodded toward Northline's first witness, a planning officer. His testimony slid neatly into corporate talking points: jobs, efficiency, tax base. During cross-examination, Maya fumbled a technical clause in the zoning code. Carter smirked. Perhaps counsel needs a refresher course, he said, words pitched for the jury. Ruth scribbled something on a slip of paper and slid it across. Maya read it, lifted her chin, and asked, "Is it true your company filed under Section 47B to bypass the historic designation review?" The witness hesitated. I'd need to consult our legal team." Carter's grin faltered. The courtroom buzzed. Moments later, Ruth rose, cane tapping once against the floor. "Your Honor, I respectfully request to be added as co-counsel of record." The judge studied her credentials, then looked up. "Request granted." Carter checked his watch and sighed theatrically. "Amateur hour," he muttered to his colleague, loud enough for half the room to hear. Judge Naomi heard it too, though she said nothing. Ruth stepped forward, steady as rhythm. The notebook opened like scripture, edges yellowed with years. The hum of the fluorescence deepened. Somewhere a juror cleared her throat. What Carter Reeves didn't realize, what no one yet understood, was that every word he flung so casually across the courtroom would soon come back sharpened by the hand that had written the law itself. And that quiet, patient woman with the cane, she was just getting started. The hum of the lights held steady, a thin electrical note you could almost mistake for nerves. Ruth stood there with her notebook open, the pages dense with neat blue script and tags of yellow paper that fluttered whenever someone walked by. Maya watched her grandmother's fingers settle on the margin, the same way a pianist rests a hand above the keys just before the first chord. Calm, exact, unhurried. A memory flickered. Sun on the courthouse steps that morning, the stone warming through the soles of Maya's shoes. They'd parked 2 blocks away because Ruth preferred to walk the last stretch, to arrive on her own terms, she always said. On the way in, a young associate in a cobalt suit had glanced past them toward the revolving door, and Maya caught the moment his eyes slid over Ruth's cane, then over her face, then away, as if the cane said more than the woman holding it. When he realized an elevator was taking too long, he cut around them and jogged up the stairs, glancing back just once with a tight smile that said, "Bless your heart," without moving his lips. Inside, Ruth had greeted the bailiff by name. She knew which hallway smelled like floor wax and which had the faint lemon of the cleaners who came in at dawn. She knew which elevator doors rattled and which ones you could trust. Maya still collected details like that, but Ruth had sorted them into categories years ago. The human map of a building and its habits. They'd stopped at a notice board between the elevators, and Maya had watched her grandmother read the docket the way other people read faces. They stacked land use motions for the afternoon, Ruth had noted. If we're still going by then, patience will be rare. She tapped the edge of the paper with her cane. One soft click. So we'll earn it. Now, in the courtroom, patience was a resource being spent. Carter leaned back, legs crossed, hands clasped on his knee like the cover of a firm brochure. His assistant whispered something and slid him a fresh legal pad. He didn't look at it. He looked at the jury, then at the judge, then at the clock above the double doors, then at Ruth again, like he was measuring how much time a dismissal took in real life. Judge Naomi adjusted her glasses. "Plaintiff, you may proceed." "Thank you, Your Honor," Maya said, and found her breath. She had practiced this opening a dozen times at her desk, a dozen more at the kitchen table where Ruth pretended to read the paper but corrected her cadence by clearing her throat at the wrong words. Now she kept the lines but let the air between them widen so the room could step into the story. "The South Shore Cultural Hub never asked to be old," she began. "It became old because it survived. It housed black-owned shops when banks wouldn't lend. It rented space to civil rights lawyers when landlords used renovation as a polite way to say not you. It taught piano upstairs on Saturdays and hosted a teen coding club on Tuesdays, long before anyone wrote STEM in grant applications. The hub isn't a relic. We can call witnesses who opened their first business in that building last year. Carter popped up. Objection. Counsel is testifying. This is an opening statement, Judge Naomi said. Overruled. Keep going, Ms. Ellis. Maya nodded. We will show that Northline Urban Ventures filed under Section 47B, an administrative lane that bypasses historic designation review, after preliminary outreach flagged the building as culturally significant. We'll show that there were alternatives. That policy allows for discretion. They chose not to use it. Carter stood, palms out. Objection. Prejudicial language implying bad faith. Overruled, the judge said. The jury will decide intent. Maya breathed in. The taste of copper faded from her mouth. She described a handful of tenants. Mr. Rivers, the barber with Polaroids of 3 generations of first haircuts. Ms. Lattimore, selling vegan pies because her father's diabetes had scared her into a new kitchen. The community bank kiosk with a Saturday line that wound past a thrift shop window specializing in church hats. When she finished, she returned to her chair like a diver resurfacing and waited for the world to sound normal again. Ruth laid a hand on her wrist. Good work, she whispered. You kept the record straight. Northline's first witness, a planning officer named Daniels, spoke in the gray tone of career bureaucracy. The project supports job growth, infill development, and a broader tax base. And your community impact assessment? Ruth asked when she stood for cross, voice as even as the second hand on Judge Naomi's clock. We posted notices, we hosted an open house, he said. Ruth's pen drew a small circle. Dates and times, please. The exact ones, and languages. He cleared his throat. English. No Spanish? She said. No Polish? No Mandarin? No notices at the hub itself? We posted on the city website. Ruth didn't sigh, though Maya felt the urge pass through her body like a wave flattening. Any sessions after 5 p.m.? Ruth asked. Sundays? No. So your outreach was non-linguistic during working hours at a location outside the affected block. She paused. And you call that comprehensive? Objection, Carter said, quick as a lighter. Argumentative. Withdrawn, Ruth said. Mr. Daniels, do you recall which statute governs admissibility of community impact evidence when outreach is completed prior to application? He blinked, looked toward Carter. Your Honor, Carter said, smooth grin rising, this line is misdirected. Ellis v. Ridgeland set clear boundaries. If counsel needs a refresher... Mr. Reeves, the judge warned. He spread his hands. I mean to say, sentiment is admirable, but the law is controlled by facts. And facts here are jobs and revenue. Ruth's pen clicked shut. Facts, she said, lose meaning when you shrink them to the parts that serve you. She turned back to Daniels. Nothing further. A sound like soft wind moved through the room, the shift of 30 people repositioning at once. Before lunch, there was a lull, paperwork exchanged, sidebar whispers. Carter tapped his Mont Blanc against a legal pad and pretended not to scan the gallery. He met eyes with a man in a suit so expensive it looked casual. The kind of man who paid other people to make his calendar and never learned their last names. The man nodded once. Carter nodded back. We're fine. Maya's focus drifted to Ruth's notebook, the edge frayed and furred like an old bookmark. Once, at 10, Maya asked why Ruth always wrote in blue ink. Ruth said, because it looks like the truth without yelling. At 15, did that mean black ink was dishonest? Black ink is decisive, Ruth said. Blue suggests a conversation. At 23, after her first semester in law school knocked the breath out of her, Maya asked what any of it mattered when power didn't care about ink. Ruth closed the notebook, looked at her like deciding whether to give away a family recipe. Power cares about what it can't burn, she said. Records, precedent, names. The clerk called the next matter, and the day folded into afternoon. In the hallway during recess, the air was cooler, smelling like dust that settled a long time ago. Carter held court by the vending machines, imitating Ruth's posture to the low laughter of an associate who wasn't brave enough to laugh loudly. Her face, he was saying. When I quoted Ridgeland? Classic. Jenna Ruiz moved past with her steno case rolling behind, tiny wheels rattling over a seam in the tile. She didn't break stride, but her eyes found the far wall and hardened for half a second, the way they do when you watch a stranger shove someone you love in a crowd. Maya found her grandmother in a small consultation room where the carpet swallowed footsteps. Ruth had the notebook open, transcribing onto a yellow legal pad, handwriting straight as a plumb line. We should file a complaint, Maya said, too loud in the quiet. You heard him, you saw him. Ruth capped the pen. There's a time for complaints and a time for strategy. What does that even... Sit, Maya. The tone wasn't sharp, but it wasn't optional. Maya sat. Ruth took her hand, rubbed a thumb across the ridge of a knuckle, the way she had when Maya was a kid with skinned knees. When I told my high school counselor I wanted to be a lawyer, he told me I'd be happier in a secretarial pool. In my study group first year, a professor asked me to pour coffee. When I placed third in my class, a partner asked how fast I typed. She looked down at her notes. I don't spend anger where preparation yields more. You knew this would happen, Maya said. I suspected it might, Ruth said. Men like this advertise themselves. She glanced at the time, picked up her phone, dialed without looking. Thomas, she said when a deep voice answered, it's been a while. A pause, then warmth. Justice Ellis, you always call when the stakes are good. Do you still keep an archive for Ridgeland? She asked. I need the complete transcripts and, if possible, original notes. Judge Naomi Carter's courtroom. My courier can be there in 45, Thomas said. Should I include the draft you marked up? That would be perfect. Ruth's eyes softened. Thank you. She hung up as Maya returned with 2 paper cups of coffee and a sandwich flattened by the weight of the world. You didn't tell me you knew the court reporter for Ridgeland, Maya said. I didn't need to, Ruth said, taking the coffee. Until now. They re-entered the courtroom to a murmur that died politely as the judge took the bench. Carter rose again for his performance number, a fluid gesture he'd practiced in the mirror with shirts that matched his tie and a chin that always found the light. He called a city planning analyst who dutifully affirmed 300-plus jobs, $14.2 million in annual churn, and $1.7 million in tax revenue, as if saying numbers in a baritone turned them into facts you couldn't examine. Maya handled the cross. It went poorly. Carter objected to her foundation, to her phrasing, to her audacity, and she swallowed her frustration the way you swallow a cough when you've promised to be quiet in church. When she finally said, no further questions, she slid her chair back an inch and felt despair build at her throat. Ruth touched her elbow. May I? She asked softly. Maya nodded, mouthed, please. Ruth approached the witness box like approaching a piano bench. Good afternoon, she said. In your multiplier for indirect job creation, which model did you use? Henderson McHale, he said. 2018. For suburban greenfields, Ruth said. You adjusted for an urban infill mixed-use context? Yes, he lied. Which adjustment? She asked. He hesitated. She waited. The pause expanded until it had weight. He admitted he'd used the commercial property variable in the third term of the Grayson tax formula. For mixed use, you need the residential adjustment factor, Ruth said mildly. By my math, your error inflates revenue by approximately 24%. Objection, Carter's voice cracked, then recovered. Your Honor, counsel is editorializing. We can address any miscalculations on redirect. Overruled, Judge Naomi said. Answer the question. It's a minor oversight, the analyst said, cheeks pinking. In a city budget, 24% is not minor. Ruth smiled, pleasant as a librarian, and returned to her table. Carter lunged for redirect, framing the oversight as a rounding error. The man in the expensive suit unbuttoned his jacket, then buttoned it again. A gesture of people who prefer the world remain exactly as arranged in their calendars. A courier slipped into the back of the courtroom as quietly as an idea. He handed an envelope to the clerk, who scanned the label, lifted her eyes to Ruth, and gave the smallest nod. Ruth slid the envelope beneath her legal pad without opening it. A small private storm banked for later. The plaintiff's expert, Dr. Lila Montgomery, took the stand next. She spoke like a teacher facing students who didn't yet know why the subject would save their lives. When we say historic, we often mean architecture, she said, but the law distinguishes between general historical association and documented cultural significance with ongoing function. The latter means people still use this space to do things that matter, economically, artistically, politically, communally. Carter tried to corral her into a yes or no trap. Is the building on the National Register of Historic Places? Does it have recognized architectural importance? No, she said, but... So, there we have it, he cut in, smiling at the jury. A nice story, no legal traction. Ruth rose slowly. Your Honor, Williams v. Metro Redevelopment distinguished precisely this, general association versus ongoing cultural function. Carter didn't miss a beat. With respect, counsel may be quoting an outdated note set. Memory does play tricks. The room inhaled as one. Judge Naomi's eyes sharpened. Mr. Reeves, she said, voice cool enough to make a July day think twice. Apologize now. Carter's jaw worked. My apologies, he said, performing contrition the way a magician produces scarves. Jenna Ruiz didn't look up, but her fingers slowed for 2 keystrokes, like a drummer catching something no one else heard. By late afternoon, the judge called a recess. The room exhaled its people into the hallway, lawyers with rolling cases, jurors pretending not to look at anybody, the gallery trying to remember what they'd heard and how they felt about it. Maya sank onto a bench, dug in her bag for a pen she didn't need. She thought about the hub's hallway on a Saturday. Laughter, scuffed baseboards, Mr. Rivers telling every kid with a fresh cut they looked courtroom ready, and how they giggled even if they didn't know what it meant. Ruth sat beside her, cane leaning against the bench, notebook on her lap. He's rattled, she said. He looks thrilled, Maya said. That's what rattled looks like when... You're too proud to sweat, Ruth said. She placed a hand over the envelope. We won't use this yet, only when it matters more than it stings. I wanted to shout at him, Maya said, voice small. Make him say your name right. Make him stop. Ruth threaded her arm through Maya's. We make him stop by making the court hear what he's doing, even when he speaks softly, she said. We make a record power can't burn. Back in 3C, Carter tried a new gear, gentle pity, the tone people use when they want to humiliate you without looking like the kind of person who enjoys it. He drew out a line about progress and how modern cities must make hard choices. He shook his head with a sadness he didn't feel. He called it pragmatism. Ruth let him. Every once in a while, you let a man say more than he should, so when he lands, the ground will be harder. By the time the judge dismissed them for the day, the clock read a minute shy of 5. The lights changed tone in the high ceiling, colder for the emptier evening. People shuffled programs and calendars and obligations. The jurors filed out, like pews after a sermon that surprised them. Quiet, thoughtful, unsure whether the surprise was comfort or warning. Ruth closed her notebook, tied the elastic with one practiced flick, and stood. The cane tapped once against the carpet. She looked across the aisle at Carter. For a heartbeat, they made eye contact. He gave a confident little nod, the furthest thing from respect. It looked like a man who'd already written the ending in his head. Maya reached for the briefcase. "Tomorrow," she said, more hope than prediction. "Tomorrow," Ruth agreed. She didn't sound hopeful. She sounded certain. On their way out, a cleaning woman in a green smock opened a door with her hip and waltzed a trash bin through the gap. "Evening, Ms. Ellis," she said when she saw Ruth. "You wear that blue like a promise." Ruth smiled, trying to keep it. The hallway stretched long and quiet. The city waited behind the revolving doors with its same old noise that could still sound new if you walked into it with purpose. Above the steps, the sky had softened to the pale gray that makes streetlights matter. They stood at the top for a second, the wind lifting Ruth's hat the smallest bit, and looked down at Halstead, where a bus brake hissed and a bike light bobbed across the intersection like a point of faith. Maya tucked the notebook deep into her bag. She didn't ask what was in the envelope or what was on the pages Ruth had marked in blue. She didn't have to. Tomorrow would open it for them, whether Carter wanted it opened or not. They descended the steps together, one measured tap, one steady breath, exactly in rhythm, as if the day had been rehearsing them for the moment they'd require perfect timing. By morning's second coffee, the courthouse had settled into its rhythm. The shuffle of shoes, the cough discreetly swallowed, the muffled slam of a door 2 corridors away that always sounded like a verdict. Maya counted each of those sounds because they steadied her. Ruth didn't seem to need steadying. She carried her stillness like a skill. They were already seated when Carter swept in with his entourage, the fabric of his suit whispering the kind of money that behaves like a fact. He gave a polite nod to the clerk, offered a too bright smile to the jurors, then let his gaze pass over Ruth as if she were a painting that came with the courthouse. Maya felt heat crawl up her throat. Ruth's fingers tapped once at the edge of her notebook, just enough to tell Maya she'd seen it, counted it, assigned it a place on the shelf marked irrelevant to outcome. "All rise," the bailiff called, and Judge Naomi took the bench. It was the same calm as yesterday, the kind that made people sit up straighter without thinking about it. "Mr. Reeves," she said, "you may proceed." Carter rose, buttoning his jacket with a small flourish that caught the light. "Your Honor, Northline calls Mr. Daniels back for brief redirect." He walked toward the witness box with a softness he had practiced, because practiced softness often gets mistaken for sincerity. "Mr. Daniels, to clarify yesterday's discussion of Section 47B, would you agree that the code anticipates efficient pathways for development when economic impact is demonstrable?" "Yes," Daniels said, grateful to be led. "Efficiency is a core principle." "And while community input is valuable," Carter went on, turning just enough for the jury to admire his profile, "the law prioritizes objective metrics, correct?" "That's my understanding." Ruth's pen stopped moving. The blue line she'd been drawing in the margin ended with a tiny dot. Maya felt the dot somehow like a drop of rain. Carter continued, "And as to the so-called historic review, the statute does not require it for facilities lacking architectural significance. Would you agree?" Daniels nodded. "Yes." Carter turned his palms out toward the jury, helpless in the face of reason. "No further questions." Maya rose for recross. "Just one, Mr. Daniels. When you say lacking architectural significance, are you drawing that phrase from the HCPA itself or from Williams versus Metro redevelopment?" He blinked. Carter's head tilted like a hawk watching a mouse consider an exit. "I believe it's the statute," Daniels said. "Your Honor?" Maya lifted a single-page printout. "The HCPA makes no such categorical reduction. It uses a composite test that includes cultural function. The phrase counsel put in Mr. Daniels' mouth comes from Williams, which is about distinguishing general association from documented cultural significance with ongoing function. Different animal. Same neighborhood." Carter stood. "Objection. Counsel is editorializing." "Overruled," Judge Naomi said. Mr. Daniels may answer. Daniels looked at the printout with the expression of a man who just realized an elevator wasn't taking him where he thought. I misspoke. Thank you, Maya said, and sat. Carter's jaw worked once, the muscle near his ear flexing. He recovered in a blink. No further witnesses on this point, Your Honor, he said. At this time, Northline calls Alan Brooke, Senior Analyst, City Planning. Brooke entered with a tidy gray tie and a nervous habit of smoothing it. The look of someone who knew the code the way a mechanic knows the sound of a car's bad belt. Intimate, practical, slightly ashamed of the age of the parts. How many applications for infill development have you processed this year? Carter asked. 74, Brooke said. And is the South Shore project consistent with city goals for density and job creation? Yes, Brooke said. On paper. On paper, Carter repeated with a smile, as if turning the phrase into a joke absolved it of meaning. And 47B is a lawful filing route? Yes. Thank you. Ruth stood for cross. Mr. Brooke, did your office consider any alternative parcels within a half-mile radius that would meet the same goals without disrupting an active cultural hub? We did not conduct a formal alternatives analysis, he said carefully. It's not required at that stage. Required isn't the same as prudent, Ruth said, like a teacher fond of her students despite everything. Did your office informally then glance at vacancies? We have vacancies, he admitted, but they're not as attractive. Because? Because the hub is central, he said, and because people recognize it by name. Visibility matters. Ruth's eyebrow moved barely enough to count. So your economic case depends, in part, on the very cultural footprint you later argue is meaningless? Carter was up before the sentence landed. Objection, argumentative. I withdraw the implication, Ruth said easily. Mr. Brooke, did you personally visit the hub before offering your opinion? He hesitated. No. Did you attend any of its public programs? Saturday microloans, Tuesday coding? No. Ruth nodded, as if he had given her what she needed. No further questions. Carter took 2 steps toward Brooke and stopped as if reconsidering a flourish. Just to clarify, your opinions are based on data models and policy frameworks, not so-called vibes, correct? Brooke looked pained. Correct. In sum, Carter concluded, development is good. Judge Naomi's eyes flickered down to her notes, then up. Counsel, keep your summations for closing. Yes, Your Honor. The morning thinned into lunch. In the cafeteria, with the humming ice cream freezers and the wilted lettuce bowed under ranch, Carter held his impromptu press conference for no press at all. 2 associates and a Northline executive whose cufflinks cost more than Maya's rent. He mimicked Ruth's cane tap, the rhythm, the curved wrist, and the table laughed as if they were required to. That face when I read Ridgeland, he said, delighted with himself. Classic! Maya kept walking past them, but the words salted the back of her tongue. She took the stairs back up because the elevator felt too tight for anger. In the little consultation room, Ruth had a sandwich she hadn't unwrapped, and the yellow legal pad moved 3 inches since morning. How many times did he say efficient? She asked without looking up. 4, Maya said. Maybe 5. Why? Because when men like that repeat a word, they're building an alibi, Ruth said. And because juries hear repetition louder than logic. Maya sat and touched the envelope under the legal pad like a talisman, though she didn't remove it. We could end this with one reveal, she said. Thomas's package has your notes, your draft. We could stand him up against it and let him squirm. We could be done. Ruth's mouth softened. Revenge is quick, she said. Structure is slow. If all we do is embarrass him, he keeps his story about an unfortunate misunderstanding. If we make the record about pattern, policy, and procedure, The shell LLCs, the bypass of review, the inflation of revenue, then the next Carter who tries this will have to talk to our facts first. Maya blew out a breath. Okay, structure. Structure, Ruth echoed. Finish drafting your cross for Perkins, no speeches. A series of doors he will open himself, and flag Williams, line 5 of the second holding. You'll need it when he pretends culture means a plaque and not a job. Got it. Carter's voice from the hall swelled and faded with his proximity. Not our fault she doesn't understand the modern economy, he said to someone who laughed too hard. Ruth's eyebrow dipped 1 millimeter, the only sign she'd heard. They went back in. Perkins would be tomorrow. Today, Northline had a final witness, a junior acquisitions manager who wore nerves like a cheap cologne. He had numbers printed in 16-point font and kept licking a thumb to turn pages that didn't need turning. Under Carter's gentle coaching, the numbers sounded certain. Percentages, trajectories, multipliers that do what multipliers do when you feed them optimistic inputs. Maya handled the cross first and got nowhere useful. She thanked him anyway because Ruth had taught her that politeness pins a person to their own testimony. Ruth followed with 3 questions that did the same thing in half the time. By the third, the manager glanced at Carter the way a kid looks at a teacher when he's lost his place during a recital. It was enough. Carter stood and made a show of checking his watch. There it was again, that little tick of performing boredom. Your Honor, he said, before we recess, a point of law. Counsel has repeatedly suggested that community impact can supersede economic benefit where programmatic function persists. But Ellis v. Ridgeland, and this is basic, established that documented economic analysis rules the frame when properly conducted under 47B. To be painfully clear, community sentiment cannot override a qualifying analysis. He pivoted toward Ruth with a smile polished smooth as glass. Perhaps we should pause to explain what precedent means in a legal context. A few jurors stiffened, not just at the words, but at the way he curled them around her age, a soft velvet wrapping around a hard thing. Ruth stood. Your Honor, if I may. Briefly, Judge Naomi said. In Ridgeland, Ruth said, impact statements were excluded because they were conducted after the application. The holding explicitly notes that properly conducted pre-application assessments are admissible. She folded her hands. That is not sentiment, that is law. Carter's smile held. That's a creative reading. Which subsequent ruling altered that? Ruth asked. Keating v. Ashland, he said, too fast. Ruth didn't blink. Keating says nothing about timing. It affirms the weight of economic studies when uncontested. We are contesting. He spread his hands, patient with the elderly, with the unpracticed, with the uninitiated. Memory gets... Mr. Reeves, Judge Naomi said, voice flat as a marble step. I warned you yesterday. He swallowed a quip. Maya watched the muscles in his face rearrange themselves into compliance. Apologies, he said to the room, and to Ruth without looking at her. Accepted, Ruth said, and sat. Carter pivoted to the jurors like a game show host reading rules everyone already knew. He quoted a paragraph number and a clause. Protocol compliance supremacy, as if the city code had been waiting its whole life to be called that. Ruth thanked him simply, as if he had done her a favor. Carter's mouth twitched. Something in his body couldn't decide whether to feel victorious or exposed. The clerk made a note. Jenna's fingers paused, then kept pace. You could feel the courtroom breathe again. Not relief exactly, but the automatic human adjustment that happens when a heat source moves a little farther away. By late afternoon, attention had grown scarce. A juror rubbed the bridge of her nose. Another stared at a scuff on the floor and imagined, maybe, being anywhere else. Judge Naomi looked at the clock and back at counsel. We'll break here, she said. 2 p.m. reconvene. The gavel's crack this time was gentler, a tap more than a strike. People rose and flowed toward the doors in their precincts, defense to the right, plaintiffs to the left, the gallery to wherever stories are told when there's no record. Back in the consultation room, Maya set down 2 waters and a bag of almonds. He'll double down tomorrow, she said. He thinks he won the optics. He won a camera that doesn't exist, Ruth said. Optics don't change text. We'll use text. She pulled the envelope free, weighed it in her palm like a fruit. Not yet. Why keep holding it? Maya asked. We could end his charade. Because if the reveal ends the day, all anyone remembers is the reveal, Ruth said. I want them to remember the numbers, the bypass, the silence and outreach, the avoidance of alternatives. Then, when we open this, it will feel less like a spectacle and more like a correction. Maya considered that. She thought of the barber's Polaroids, the coding club's pizza boxes, Ms. Lattimore's pies cooling near the window where the light makes everything look blessed. She nodded. Okay, text first, then correction. Ruth smiled, small and real. Draft your questions for Dr. Montgomery, she said. Flag the distinction exactly. Make it a step stool the jury can climb, and then make it so simple Mr. Reeves will accidentally agree with you. Maya laughed, a short sound. A miracle, she said. A plan, Ruth said. They packed slowly. On their way out, they passed Carter near the elevator. He was telling a North Line executive a story made of his own eyebrows. He glanced over as they approached and gave them a nod he must have believed counted as gracious. See you tomorrow, Maya said, more to the air than to him. Count on it, Carter replied, as if attendance were courage. The elevator doors slid open. The 3 of them, the 2 women and their quiet resolve, stepped in. Carter stayed behind. As the doors met in the middle, Maya caught a last sliver of his reflection, adjusting his tie. It looked like the prelude to a victory photo he'd already imagined. Outside, dusk put a blue film over the courthouse steps. Buses sighed. The streetlights warmed from orange to steady glow. The city was the city, tired, busy, alive in the way places get when people insist on loving them despite everything. Maya breathed it in, the recipe of it. Brake dust and bakery sugar and river damp and the faint metallic tang that lives in big buildings. They didn't speak much on the ride home. Ruth flipped pages in the notebook, penciling small arrows between the lines she'd written in blue. Every so often, she would look out the window as if the glass itself had something to tell her. When Maya pulled to the curb in front of Ruth's place, the older woman rested her hand on Maya's forearm. You did well, she said. It didn't feel like it, Maya said. It did from where the record sits, Ruth said. And the record is where the law lives long enough to matter. Maya walked her to the door. The porch light clicked on by sensor, as if the house recognized the rhythm of Ruth's steps. Inside, the air smelled faintly of lemons and old books. The living room wall was lined with framed photographs of strangers who didn't look like strangers if you knew the stories that brought them there. Clients who brought pies, interns who brought babies, lawyers who brought apologies years late. Ruth set the envelope on the dining table like a guest. Tomorrow, she said, meeting Maya's eyes. We open it only if he insists on pretending the law is his to invent. Maya nodded. He will. Ruth's smile showed the exact number of years she'd been patient. Then we'll invent nothing, she said. We'll simply read. The next morning, the courthouse air would taste like coffee gone cold and adrenaline reheated, and the same men would adjust the same ties. The fluorescents would hum. The bench would rise. The city would hold its breath in all the places where breath had too often been taken. And in courtroom 3C, the woman with the cane would bring out the same blue ink and write the next line of a record no one would be able to burn. For tonight, though, Maya drove home down Halsted with the windows cracked, letting the late breeze finger the edge of her frustration and carry some part of it away. She pictured the hub lit from within. Small businesses closing their registers, kids packing laptops into backpacks, Mr. Rivers sweeping up hair like confetti after a parade, Miss Lattimore labeling pie boxes for the morning. She pictured Carter's face when he realized the ground he'd been preening on was a bridge someone else had built, someone who'd remembered to put guardrails on it. At a red light, Maya whispered the words without meaning to. "Structure," she said, then correction. The light turned green, and the car moved forward the way stories do when someone decides to stop being loud and start being clear. Morning came in the color of old nickel and coffee. The courthouse collected people the way a harbor gathers boats. Slow, purposeful, each with a motor of its own. Maya checked her watch twice before they reached the security line, not because they were late, but because she wanted something to measure that wasn't fear. Ruth nodded to the guard who waved her through with a familiarity that made the line move faster. They reached courtroom 3C as the clerk set out the pitchers of water and adjusted the microphones that always drooped by noon. Carter arrived 3 minutes later with a stride calibrated to look unhurried and important at the same time. A senior partner in Northline's first row, older, colder, kept his face a perfect mask. He had the posture of a man who owned a golf course without ever playing on it. "All rise," the bailiff said, and the bench took its place. "Good morning," Judge Naomi said, and it was like a string being plucked once. Clean sound, a reminder that this was an instrument. "Mr. Reeves?" "Your Honor," Carter said, standing, voice set to warm broadcast. "Northline calls Dr. Alan Perkins." Perkins walked in with the uprightness of someone who had earned every line on his resume. Princeton Ph.D., 20 years in urban economics, gentrification studies published in journals that no one on the jury had heard of and everyone respected anyway. He carried a folder and the polite patience of an expert used to explaining the complicated to people who didn't have the time for complicated. After the oath, Carter opened with the easy pitches, degrees, publications, consulting gigs that sounded like money and municipal weight. Perkins kept his answers tight, like a runner keeping his steps compact on a crowded sidewalk. Carter glanced at the jury and let the credentials hang in the air like credentials always do, then shifted to the meat. "Dr. Perkins," he said, "what's the projected impact of the South Shore redevelopment?" 320 new jobs, Perkins said, 14.2 million in annual commercial activity, and approximately 1.7 million in tax revenue, rising with growth multipliers over a 5-year horizon. The numbers dropped into the room with that crisp sound numbers have when you say them in a serious voice. Maya felt it. The small sway in the jury box, the lean forward, the subtle awe people don't know they make when math pretends to be certainty. "What models support your conclusions?" Carter asked. "The Henderson-McHale 2018 multiplier for indirect job creation," Perkins said, "adjusted for sector, plus the Grayson formula for municipal tax projections in mixed-use developments." "Reliable models?" Carter asked. "Industry standards," Perkins said, not bragging. Carter produced 2 charts, handsome in their confidence, a line trending up, bars stacking neatly. "Are these representations of your analysis?" "They are." "No further questions," Carter said, as if yielding in perfect control of the next move. Maya stood for cross-examination before her stomach caught up. "Good morning, Dr. Perkins." "Good morning," he said, pleasant. "Let's talk about your job multiplier," she said. "You used Henderson-McHale's 2018 model." "Yes." "That model," she continued, hands steady on the lectern, "was calibrated for suburban greenfield developments with minimal existing cultural or micro-enterprise activity in the footprint, correct?" Perkins hesitated, then nodded once. "That's the standard context." "And South Shore is urban infill with embedded micro-businesses and ongoing cultural function?" "By some definitions," he said carefully. Which you did not. Wait, she said, keeping her tone neutral. Did you apply any correction factor for the displacement of microenterprise during the build-out period? We accounted for temporary disruption in our ramp-up timeline, he said. But not in the multiplier itself? We used the standard multiplier. So, no. Carter stood. Objection, badgering. Overruled, Judge Naomi said. Answer stands. Let's talk about Grayson, Maya said. Would you write the municipal tax projection formula you used on the board? Perkins rose, took the marker, and wrote with professorly confidence. The jury watched the letters and numbers bloom. Maya moved closer, like she could read better there. Now, she said, for the third term, the property category variable, you used what value? Commercial, he said. For a mixed-use plan that includes residential units, she said. It's a weighted average, he said. Commercial heavy. But you did not apply the residential adjustment factor that Grayson recommends when residential square footage exceeds 30% of the total. We considered it unnecessary for this. Please answer yes or no. Perkins tightened his jaw. No. So your 1.7 million, Maya said, is inflated. It's a difference in emphasis, he said. By how much? Minor, he said. Define minor. Perkins glanced at Carter and then at the chart like it could bail him out. Within 20, he said. 20%, Maya repeated. The number tasted both big and slippery. Nothing further, she said, choosing the edge of her competence over the drop. Carter stood as if spring-loaded. Dr. Perkins, even accepting counsel's math, which we do not, is the development still a net gain? Of course, Perkins said. Even with conservative adjustments, it's a significant improvement over current usage. Thank you, Carter said, and sat with his ankle on his knee like punctuation. Ruth touched Maya's elbow. Good, she said, quiet. Now watch. Ruth stood and approached with that patient cadence the room had learned to track. Dr. Perkins, your Henderson-McHale multiplier, does it incorporate informal economies into baseline conditions? Perkins blinked. Informal economies are difficult to quantify. That wasn't the question, Ruth said, polite as a librarian and twice as final. Does the model incorporate them as they exist at the site? No, he said. So your baseline erases the earning activity of tenants who file quarterly taxes under Schedule C and hold vendor permits, but who operate at a scale below the model's capture, she said. I wouldn't phrase it. Yet the city cashes their checks, Ruth said. Yes, he swallowed. Yes. Now, would you outline on the board your Grayson inputs? Write them large enough for the back row. He wrote. She waited. Term 3, she said. Remind the court which variable you used. Commercial, he said, shoulders angling inward a fraction. And for mixed use, Ruth said, what does Grayson recommend when residential units surpass 30%? Perkins didn't look up. The residential adjustment factor. Which you did not apply, Ruth said, so the jury would have a clean place to rest. No. By your own memo, page 4, footnote 6, you estimated residential at 38%, she said, holding up a copy. Would you read that into the record? Perkins read. His voice didn't crack, but it lost the easy glide. Let's do one more thing, Ruth said, and the room felt the small gravity of a person saying one more who knows exactly what they're counting. Let's calculate the delta using the correct factor, slowly for the record. Perkins did the math, marker squeaking. The numbers, once round, narrowed. He finished with a lower figure that made Carter's pen stop mid-scratch. By that calculation, Ruth said, your tax revenue projection drops by 24%, Perkins said, a number he wouldn't forget soon. 24, Ruth repeated, soft as a lullaby. Is that minor, Dr. Perkins? In context, he said, and trailed off. In budget hearings, context tends to look like a school roof that still leaks, Ruth said, smiling to take the sting out of the truth. The way elders in church deliver wisdom with candy. No further questions. Carter sprang for redirect. Even if opposing counsel's math holds, and again we contest application, this project remains a net win, correct? Yes. And informality is, by definition, not a stable basis for policy, he added. Would you agree? Perkins stumbled. I suppose. Thank you. No further questions. Ruth didn't stand again. She let the numbers sit where they sat. You could feel jurors turning them over like objects in their palms, testing the weight. A man in the second row mouthed 24 to himself and stared at the ceiling as if it were written there. The next witness was theirs, Dr. Lila Montgomery. She walked to the stand with the presence of a person used to carrying history without turning it theatrical. Her scarf was bright but not loud, her voice calm but not bland. After the oath, Maya did the honors. Dr. Montgomery, in plain terms, what's the difference between historical association and documented cultural significance with ongoing function? Historical association is when a place connects to past events or figures, Lila said. Ongoing cultural function means people are still using the place now to make culture, money, art, food, services, mutual aid. It's not a museum of what used to happen. It's a workshop where life is happening. Does the South Shore Cultural Hub meet that test? Lila smiled. It's practically a case study. 27 micro-businesses with tax IDs, a community banking kiosk with documented conversions from unbanked to banked, after-school programming with attendance records, and a legal aid desk producing affidavits and filings. If you can print it on a spreadsheet, I've printed it. Thank you, Maya said. No further questions. Carter stood, aiming for surgical. Is the building on the National Register of Historic Places? No. Recognized architectural importance? No. So no recognized historic status, he said, turning slightly to the jury. Yet you asked the court to treat it like one. Objection, Maya said, misstates the testimony. Overruled, Judge Naomi said. Rephrase, Mr. Reeves. You're asking us to elevate cultural function over architectural distinction, correct? I'm saying the law recognizes both as distinct paths, Lila said. Williams v. Metro Redevelopment spells that out. Carter smiled with what he thought was patience. With respect, counsel's witness may be working from an outdated note set. Memory plays tricks. The room cooled. Judge Naomi didn't look up. Mr. Reeves, apologize. He did. Lab-grown contrition. My apologies. Accepted, Lila said, the corner of her mouth twitching like she'd seen better performances in middle school plays. When she stepped down, the court shifted. Something had moved that wasn't just paper. Recess. In the hallway, Maya met Jenna Ruiz at the water fountain, 2 bobby pins crossing like an X. He does that on purpose, Jenna said. Says it just under a line he thinks I won't catch. You always catch, Maya said. That's my job, Jenna replied, and for a second, solidarity held more weight than people realized. Back inside, the afternoon warmed toward the hour when attention sags. Carter tried to gin up enthusiasm with an acquisitions manager who said pipeline and synergy so often the words lost their handles. Ruth declined cross. No questions, she said, as if saving her voice for something that deserved it. The clerk glanced to the back. A courier stood there, notepad in hand, expression neutral from 100 courtrooms. The clerk gestured. He delivered an envelope. She checked the label, then looked at Ruth. The tiniest nod passed between them. A bird landing on a wire. Ruth didn't open it, not yet. She rested her hand lightly on it like it was the back of a sleeping child. Any further witnesses? Judge Naomi asked. None for today, Carter said, pleasant as ever. We'll recess until tomorrow morning, 9 a.m., the judge said. Counsel, his approach. At the bench, voices dropped. The white noise machine hummed, cocooning the conversation. Whatever was said made Carter say, "Of course, Your Honor," in a tone that sounded like I'm not pleased, dressed up as I am very professional. Dismissed, the room loosened its collar. People stood, stretched, found their bags. A juror checked her phone and made a face. The forgotten dentist appointment. The Northline senior partner touched Carter's elbow, proprietary, murmuring something that turned Carter a shade paler for just a second. "We broke the spell," Maya said. "Spells are just stories that forgot their stories," Ruth said. "We reminded the room numbers can be the truth or the trick, depending on who holds the marker." In the hall, cooler air, softer hum, a text lit Maya's phone. Delivered Ridgeland, complete. Original draft plus margin notes. T. She held it up. Ruth's eyes warmed, nothing more. "Tomorrow?" Maya asked. "Tomorrow," Ruth said. "If he insists on inventing the law again, we'll show him who wrote the dictionary." "What about Brooke?" Maya asked. "He'll be back on redirect or in rebuttal. The type to pretend discretion equals destiny." Ruth smiled. "Then we'll remind him discretion without duty is just laziness in a suit." They rode the elevator down in small, peaceful silence. Outside, late afternoon light hit the courthouse facade and turned the marble back into stone. A bus shuddered at the curb, releasing people with faces angled toward dinner, second jobs, or the nap you promise yourself and don't keep. On the steps, a young woman with a stroller hesitated, then approached. "Miss Ellis?" Eyes bright. "My mom said to tell you the hub helped her fix a loan thing last year. She said tell you thank you if I ever saw you." Ruth's smile reached to the place where gratitude lives. "Tell your mom she paid me with that message," she said. "What's your name?" "Shanice," the woman said, bouncing the stroller to keep the baby asleep. "Nice to meet you, Shanice," Ruth said, as if each syllable were a gift. "See you at the hub sometime." They parted on the steps. Ruth and Maya walked toward the car with the rhythm they'd worn into their bones. Tap, step, tap, step. The cane marking time, the city keeping beat. Maya felt the envelope through the fabric of her bag, a square of promise. She thought about tomorrow, about numbers and notes and a man who had confused volume with victory. "Do you ever regret it?" she asked at the corner. "Not just today, all of it. The restraint, the waiting." Ruth considered. The walk sign flicked to white. They crossed with the small procession of strangers traveling in the same direction for different reasons. "Sometimes," Ruth said, "but I regret more what happens when I don't wait the right amount." "What's the right amount?" "Until the truth can't be mistaken for a trick," Ruth said. The wind came up from the lake and lifted the hem of Ruth's coat just enough to make the lining flash. The light turned, cars eased forward, and they stepped onto the far curb. A cyclist rang a bell, and the bell sounded like something beginning. That night, Maya fell asleep at her kitchen table with the cross for Perkins still open and a note to herself that read, "Make it a series of doors. Let him choose to walk through." Ruth, at her dining room table, wrote 2 sentences on a legal pad in the same blue ink she always used. She placed the envelope beside it and turned off the lamp, leaving both things in the dark the way you leave bread to rise. Quiet, inevitable, alive, even when no one is watching. Morning would arrive with the same nickel light and the same coffee. Carter would wear a different tie and the same confidence. The numbers would still be the numbers, but now they belonged to the record as much as to any man. And when the time came to open paper that knew more than a mouth could fake, the room would already understand why it mattered. The courthouse smelled like printer heat and rain-soaked wool, though the sky was dry. People carried their weather inside. Ruth and Maya stepped from the elevator into that weather and felt the pressure change. The barely audible hush of a room that had learned not to underestimate them and was trying clumsily to decide what that meant. By 9, courtroom 3C was full. The North Line row looked pressed and polished, a rack of suits arranged by confidence. Carter's tie today was a sober navy, as if the color alone could say restraint. In the gallery, a new presence. A man with silver hair and a face that could slice paper. Harold Blackwell, senior partner. He didn't look at anyone. He let people look at him. His stillness was a kind of power. "All rise," the bailiff called. Judge Naomi took the bench and set her pen parallel to the edge of the blotter, as if the day required alignment. "Good morning, Mr. Reeves." Carter stood, voice steady. "Your Honor, North Line calls Robert Jeffers, City Planning." Jeffers had the shoulders of a man who spent more time with binders than with buildings. He swore in and sat, folding his hands tightly, as if keeping them from knocking over his own testimony. "Mr. Jeffers, please summarize the code compliance issues you identified at the South Shore Cultural Hub." 17 deficiencies, Jeffers said, clear in the way people are when they've memorized numbers to feel safe. Electrical system upgrades required, accessibility non-compliance in 2 entry points, fire suppression outdated, HVAC inefficiency beyond threshold, roofing concerns, stairwell handrail height. "Thank you," Carter said, a palm raised to suggest mercy. "If remediation were pursued, what would be the conservative cost?" $2.4 million, Jeffers said. "Minimum." "Would those costs burden public funds?" "In my view, yes." Carter paced 2 steps, then turned with rehearsed timing. "So even if this property had cultural significance, public safety and fiscal responsibility would require prioritization of code compliance, correct?" "Yes," Jeffers said. Maya rose for cross, but Ruth touched her sleeve. Ruth approached instead, cane tapping once again, the sound like a heartbeat you lean toward when the room feels too loud. "Mr. Jeffers," she said pleasantly, "when did you last visit the South Shore Cultural Hub?" "I reviewed the structural assessments prepared by our department." "So you haven't physically visited the site," Ruth clarified, still pleasant. "It wasn't necessary given the paperwork," he said. "Of course," Ruth said. "Paper is very efficient. Did your paperwork include the access ramp installed in February?" Jeffers blinked. "I don't recall." "The electrical upgrades completed in March?" A flicker of panic. "I wasn't aware." "The sprinkler system signed off in April by your colleague Ms. Hollis?" Ruth held up a scan stamped and certified. He leaned toward the page, as if closeness could attach him to reality. "It appears I did not see that." "And the stairwell handrail, adjusted to current code in May. I have the inspection here." Carter stood. "Your Honor, with respect, these improvements don't address the funda." "Sit down, Mr. Reeves," Judge Naomi said softly, without looking at him. "Let the witness answer." Jeffers tugged at his collar. "If these documents are accurate, several listed deficiencies have been addressed." "So your 2.4 million, Ruth said, is a number that includes problems that aren't problems anymore." "It would need revision," he admitted. Ruth nodded with a teacher's smile. Not unkind, firm enough to move a grade." "Thank you. No further questions." Carter popped up as if the floor had cued him. "Your Honor, even granting updated figures, code compliance remains paramount. As established in..." He checked his notes with exaggerated clarity. "Ellis v. Ridgeland, when public safety is at issue, historic considerations drop below compliance. And to preempt counsel's inevitable attempt to conjure exceptions, those do not apply without full funding secured prior to application. There's no wiggle room. That's the Turner Amendment to Ridgeland. Basic property law." Silence fell with weight. Not the silence of confusion, the silence of a room that had heard something too neat. Ruth rose. She adjusted the angle of her notebook, smoothed one corner, then looked at Carter the way you greet a neighbor's child who's just claimed the moon belongs to him. "Your Honor, may I respond briefly on the law Mr. Reeves just cited?" "Please," Judge Naomi said. Ruth faced the jury, then the bench. The fluorescents thrummed. "There is no Turner Amendment to Ellis v. Ridgeland," she said. Carter's smile tilted. "Perhaps in your day, Ms. Ellis, but—" "In my day and in this one," Ruth said, even. She turned to the clerk. "Ms. Dunn, please mark for the record the certified transcripts and original notes for Ridgeland provided yesterday, including the draft majority opinion annotated by its author." The clerk blinked, then nodded. "Marked and entered." Ruth rested a hand on the manila envelope like greeting an old friend's shoulder. "I know with absolute certainty there is no Turner Amendment, because the majority opinion in Ridgeland contains no such language." She lifted her eyes to Carter. "I wrote it." The room gasped, not theatrically but involuntarily, air-changing shape. A juror's pen stopped mid-scribble. Someone whispered, "Oh," and the whisper folded into silence. Judge Naomi tipped her chin. "For the record, please state your full prior position." Ruth Ann Ellis, former Associate Justice of the State Supreme Court, author of the majority opinion in Ellis v. Ridgeland, and a member of the drafting committee for the Historic and Cultural Preservation Act. I retired 5 years ago to direct the South Shore Cultural Hub. Carter found a word and grabbed it. "Your Honor, had I known—" "That is precisely the problem," Ruth said gently, not looking at him. "Your conduct shouldn't depend on my resume. The law doesn't care how loudly anyone talks. It cares what's true." Judge Naomi nodded once. "The court accepts the authentication. Mr. Reeves, you will refrain from inventing citations." "Yes, Your Honor," he said, and the words cost him. Ruth slid a second bundle to Maya. Addresses, dates, LLC names, tied by arrows that made a pattern even a casual glance could recognize. Maya stood. "Your Honor, may I approach?" "You may." A binder. A chartboard easel with early morning tape. 7 shell companies. Argyle Holdings, Halcyon North, Cobalt Parlor, Marsh and Vine, and 3 others with names so smooth they almost slid out of memory, all resolving to Northline Urban Ventures. "For 5 years," Maya said, steady, "these 7 LLCs acquired properties in historically black neighborhoods at an average of 18% below market, while paying premiums of 12 to 16% in adjacent majority white tracts for comparable square footage. Overlay city filings and you see strategic use of 47B to bypass historic review in majority black corridors." Carter rose, objection on his lips, but the judge's lifted palm sat him down before she spoke. The red dot of a laser trembled. Hands do that when they hold consequences. "This pattern doesn't prove intent," Maya said, "but it reveals practice. And practice in law matters." Ruth turned to Alan Brooke. "Mr. Brooke, did your office cross-reference LLC ownership chains when assessing this filing?" "No," he said, too quickly, then tried to soften it. "We don't have a uniform process for that." "Did you consider cumulative impact in corridors with concentrated acquisitions?" "We lacked the bandwidth to—" "So the data was public," Ruth said, "but invisible for your purposes." He looked at his hands. "That would be fair." In the gallery, Blackwell finally moved, leaning forward into Carter's shoulder space. The syllable on his lips read, "Now." Sidebar. Carter tried a beat later. At the bench, white noise hummed like rain. Faces still. Decisions writing themselves behind eyes. When they broke, Judge Naomi's voice was formal. "The court will recess for 48 hours to allow parties to explore settlement options. We resume Friday at 10 a.m. If no agreement is reached, we proceed." Corridor air gulped them in. Blackwell rounded on Carter, voice low, and nodded. "You mocked Justice Ruth Ellis. You fabricated a citation to her opinion. Her portrait hangs in the conference room you pass daily. I Didn't know, Carter said, hearing the smallness of it as it left. You didn't look, Blackwell replied. Inside, Maya murmured to Ruth, you waited until he'd said it in open court twice. Some mistakes are educational only when public, Ruth said. He had to hear his own voice. Do we want a deal? We want change, Ruth said. If a deal secures it, we take it. 2 days later, Chambers smelled of lemon oil and printer ink. Rooms where people pretend to be calm for noble reasons and sometimes are. Blackwell. Northline proposes to withdraw its application effective immediately and to contribute $500,000 toward the hub's renovations. In addition, he said, an independent audit of our acquisition practices across the last 5 years. Conducted by whom? Ruth asked. An outside firm of mutual agreement. With authority to publish. A pause. With authority to publish. Community Advisory Board, the director added, with decision authority over impact conditions in designated corridors. Residents, small business owners, historians, youth representatives. With real veto power, Ruth said. With real veto power, the director echoed. And an apprenticeship pipeline for minority contractors and trades, Blackwell said. Paid, clear on ramps, 3 years. Ruth nodded once. That addresses the property, the pattern, and the pipeline. One more condition. She turned, not unkind. Mr. Reeves' conduct, deliberate misrepresentation, fabrication of a non-existent amendment, apologies without correction. Northline will not oppose a referral to the State Bar's disciplinary committee. In fact, it will support it. Agreed, Blackwell said, exhaling like a man signing a difficult peace. Judge Naomi drafted a short paragraph. Upon execution, the court will accept the stipulation and enter it on the record. Back in 3C, the stipulation was read into the cadence of law. Withdrawal of application, $500,000 for renovations, independent audit with publication rights, community advisory board with veto authority, apprenticeship pipeline, support for referral of counsel Carter Reeves to the State Bar for review. So ordered, she said, and the gavel touched wood. A dozen small sounds followed, papers stacked, fabric hushed, a city exhaling a breath it didn't know it had held. In the gallery, someone whispered, "Thank God." Judges drifted in to greet Ruth the way colleagues do when the work has been hard and artful. Carter sat taking inventory of tools he thought he understood and now saw differently. He met Maya's eyes, gave a small nod that said, "I'll attend to this." In the corridor, a custodian's whistle floated, setting down above them like a bird deciding on a ledge. "Lunch?" Maya asked. "Work," Ruth said kindly. "Then lunch." They signed where the clerk pointed, initialed where the clerk tapped, shook hands with the director who would help build the board they'd insisted on. First slate of names: Mr. Rivers, Ms. Lattimore, a high school senior from the coding club, Dr. Montgomery, a housing counselor from a church 3 blocks over. Ruth added, 1 seat reserved for a person under 21, rotating annually. "Policy," she murmured, stepping into daylight. "It's better when it can grow." The wind off the lake had a clean edge, people on the steps with lunches and lives. "We should send Thomas a slice of Ms. Lattimore's pie," Ruth said, amused. "The kind that tastes like you were wrong yesterday and right today." Maya laughed. "That a flavor now?" "It is where I come from," Ruth said. A young reporter approached. "Can I?" Center, a calendar invite for a first board meeting, a scanner feeding pages of an audit that would not be hidden. None of it a parade. All of it the work parades pretend to celebrate. As the sun angled low, Ruth opened her notebook and wrote 1 sentence across a clean page in blue ink, then another. She underlined a word, not twice, just once, and set the pen down. "We built the bridge," she said to Maya, who was reading over her shoulder. "Now we see who crosses." It didn't feel like an ending. It felt like another court building. Different seal on the wall, different carpet graining underfoot, different portraits staring down. The State Bar's hearing room was paneled in a dark wood that had learned 1,000 names and the consequences attached to them. The fluorescence hummed in a deeper key, the note you hear when someone clears their throat before saying a thing that will matter for longer than today. Maya adjusted her chair beside Ruth and scanned the small audience. 2 reporters very much off the record, a cluster of attorneys with professionally neutral faces, and a few community members who'd taken 2 buses to be here. People who knew that ethics isn't a word in a handbook, it's a door or a lock depending on who is holding it. Dr. Lila Montgomery sat near the aisle, arms folded, alert, calm. Jenna Ruiz slipped in at the back, hair pinned in that neat cross of bobby pins. Court reporters find their way to rooms like this the way birds find thermals. At the far table, Carter Reeves looked smaller in the same suit. The confidence was still there, installed long ago like wiring, but it shared space now with something that looked a lot like attention. Beside him sat ethics counsel Martin Rivera, practiced in exactly this posture, ready to speak, hoping he wouldn't have to. "Good morning," said Judge Rosalind Peters, chairing the 3-person committee. Her voice understood both lullabies and alarms. "We are convened to consider the complaint regarding attorney Carter Daniel Reeves, bar number 374821, on allegations of misrepresentation of legal precedent, fabrication of a citation, and conduct demonstrating bias in the course of a proceeding before the circuit court. Appearances?" "Martin Rivera for Mr. Reeves," Rivera said. "Carter Reeves, present," Carter said, and the words didn't stick, they landed. "Justice Ruth Ellis," Ruth said, standing. "Complainant." She sat, angled her cane so its handle wouldn't catch the table leg, and folded her hands over the weathered notebook, as if the book needed steadying. Not her. Judge Peters nodded. "We'll begin with the complainant's statement." Ruth didn't rise. She didn't need the performance of height. "I filed because I believe in the profession," she said, voice even. "Because what we allow in the room becomes the room. Mr. Reeves misstated holdings repeatedly, fabricated a non-existent Turner Amendment to Ellis v. Ridgeland, and, when corrected, suggested my age impaired my memory. That isn't advocacy. That's contempt for the record disguised as zeal." She paused, the silence calibrated. "And we don't let contempt dress up as anything." "Thank you," Judge Peters said. "Mr. Rivera?" Rivera stood, both hands on the table as if promising not to pound it. "Mr. Reeves regrets his conduct," he began, "acknowledges missteps, wishes to apologize, and—" "I'm going to interrupt counsel," Carter said suddenly, hands flat on the table, voice lower than the room expected. "Because it's mine to say." He looked at Ruth, then the committee, then down at his fingers as if they held a note he had to read from skin. "I saw an elderly black woman and decided she was an obstacle, not a colleague. I didn't do basic due diligence. I misrepresented precedent, and when cornered, I lied to make the law match my performance. I wrapped my bias in vocabulary. I weaponized memory because I could. That's the truth." The room didn't breathe for a measure. Judge Peters' expression didn't change, but something in the shape of her mouth acknowledged that plain confession is a kind of door opening. "Questions from the panel?" A committee member with salt and pepper hair leaned forward. "Mr. Reeves, would you have apologized if Justice Ellis had remained Ms. Ellis?" "Probably not," he said. "No pretend. That's the ugliest part." A small exhale moved through the audience. Not relief, exactly. Recognition. "Will confer," Judge Peters said. They stepped into the side room. The white noise machine clicked on, rainfall pressurized into propriety. Maya felt her shoulders drop half an inch. She didn't look at Ruth. She didn't want to break the current. Across the aisle, Carter stared at a spot on the table with the attention of a man who'd finally found a thing worth holding his gaze. When the panel returned, Judge Peters spoke without ceremony. Mr. Reeves, your conduct represents a serious breach. The law is a record before it is a performance. We impose the following: 6 months suspension from practice, 200 hours of ethics training with emphasis on bias and professional responsibility, 400 hours of community service to be completed at the South Shore Cultural Hub's Legal Aid Clinic, and upon reinstatement, 1-year supervision by a senior attorney approved by this committee. Quarterly reports detailing corrective practices. Do you understand? Yes, Carter said, like someone answering a question at a baptism, not a sentencing. Good, Judge Peters said, because if you treat this like optics, we'll see it. The gavel, smaller than the one in 3C, tapped once. Papers rustled, chairs scraped, people stood, no triumph, no scandal, just the gravity of a system doing one right thing while 100 wrong things waited their turn. Out in the hall, Carter caught up to Ruth and Maya, steps not yet sure of themselves. He stopped at a respectful distance. He didn't look at the cane. He looked at the woman holding it. Justice Ellis, Ms. Ellis, I'm sorry. Not because of who you turned out to be, because of how I turned out to be. Ruth considered him, the way an engineer considers a bridge, weight, weather, time. Apologies matter less than changed behavior, she said. The clinic meets Tuesdays and Thursdays. The seniors come early because the bus is unreliable. We start on time. I'll be there, he said. She nodded once. Then we'll see. 6 months is long enough to learn the shape of a new habit and short enough to know you're not done. Carter started at a table on the second floor of the hub, mismatched chairs, a printer that needed coaxing like an old dog. Seniors arrived with manila envelopes softened by years of being moved from drawer to drawer. He learned the language of property tax exemptions he'd never needed before. Quick study, slower listener, he improved at both. He taught teenagers to read a lease like a story where the villain hides in Section 12B. They liked him because he admitted when he didn't know, sleeves rolled, watch started matching attention, not clothes. Jenna dropped tamales and advice. Too much lawyer voice on the disclaimer. Just say, if we mess up, we fix it. Yes, ma'am, he grinned. The Community Advisory Board met under fluorescents that flickered only when the building wanted to be remembered. The first veto felt less like a fist and more like a hand on a shoulder. Retail proposal with aspirational prices for an audience needing dinner. Rejected. Resubmit with grocery tenancy and price guarantees in pantry staples. 2 weeks later, a revised plan looked like someone had listened to a grandmother. The audit landed with the weight of pages written without fear of losing a contract. It confirmed differential pricing patterns and recommended a city task force to standardize ownership chain checks. The city convened one and asked Alan Brooke to consult. Suit finally fit. Microphone with a red light. We had the data, we failed the duty. No applause. Someone took notes. Better. Law schools added a module, the Ellis hearing. Slides included a transcript screenshot where memory had been used like a cudgel. Students debated in rooms that smelled like dry erase and ambition. Some wandered to the hub on Thursdays to see the law without the carpet. The bar formed a bias in proceedings committee. Ruth served as honorary chair. We'll get nowhere if we pretend this is about rare dragons, she wrote. This is about habits. On the whiteboard, interruptions tracked, tone retrained, citations verified, sanction culture normalized. Maya's practice grew like plants someone remembered to water on schedule. 2 associates, Tasha Reed, hardware store sense of what tools mean, Daniel Cho, calm that earns trust in 10 minutes. Windows with honest light. Coffee maker rule on a sticky note, don't drink the first cup unless you made the second. The apprenticeship program launched on a Saturday, donuts from a shop that had survived 3 rent hikes and 1 flood. Young people and midlife switchers learned to wire a demo panel, hang a door that actually swung. Lonnie, a retired electrician, difference between a shortcut and a short. Aaliyah fixed the flicker in the hub's upstairs hall. When the light steadied, Ruth clapped once, soft, like saying grace. The grand reopening came a year to the week after 3C tilted. Stained glass repaired by a woman who makes art of broken things without making a sermon of it. A brass plaque by the door. Times sur char 200 marams. A house for signal, not noise. South Shore Cultural Hub, rededicated to the work of listening and building. People filled the hall, neighbors, artists, small business owners, a few suits who didn't pretend to belong. The coding table sign, ask us anything, except to fix your printer. A jazz trio warmed the room until it exhaled as when. Ruth stood near the punch bowl, navy and a shawl that nodded to every grandmother who ever carried a building in her pocket. People came with thank yous shaped like stories. She received each like an envelope, not in a hurry to open. Justice Ellis, a careful voice. Carter, button down, no tie, humility you can't iron in. Mr. Reeves, I'm helping with the research class. They told me to stop calling them kids. A breath. I have a request. A formal envelope. A letter, concise, unornamented, earnest without performing it. Mentorship without entitlement, habits he aims to build, metrics he'll submit, not asking her to fix him, asking her to check the work. Why me? She asked. Because you told me to write for the worst, and I was the worst, he said. Because you build things that last. I don't want my second career to be a sentence I serve. I want it to be something I can hand and not be ashamed. Mentorship isn't a medal, she said. It's a practice. Monthly check-ins, no excuses. I'll bring the record. Monthly, she agreed. Begin next week. Bring your mistakes. Evening found Ruth and Maya on the rooftop garden. Tomato plants persuaded to live past a stubborn month. Chicago insistent, lake breathing, trains stitching edges with schedule and steel. Do you ever wish you'd pulled rank on day 1? Maya asked. Spared yourself watching him teach the room to disrespect you? Sometimes, Ruth said. But he wouldn't have learned. The room would have learned the wrong story, that you get justice when a famous person shows up. I want them to know you get justice when the record is clean and the work is done. Truth as inevitability, Maya said, trying it again. With a lot of maintenance, Ruth added. Footsteps on the stairs. Carter hesitated at the top. Permission to join? She nodded. They looked out together, 3 people who had shared a room where a gavel roared and another where it ticked like a metronome. You'll keep the Tuesday shift, Ruth said. Seniors first, then youth appointments. Review your cases with Maya before you file anything for a month. Yes, ma'am. We'll make you a checklist, Maya smiled. Lawyers love checklists. I love not being a disaster, he said. Checklists sound holy. A breeze lifted the corner of Ruth's shawl. She opened the old leather notebook to a clean page and wrote in blue ink 3 lines. Write it down. Make it true. Make it hold. Downstairs, a kid shouted that the code finally compiled and the room clapped. Success is a communal sport here. Mr. Rivers taped a Polaroid of a boy's first haircut beside the father's. Same smile, different hair. Ms. Lattimore slid a pie slice to a courier who hadn't planned to stay and was glad he had. Ruth watched ordinary grace spread, the kind that refuses to become a speech. The system hadn't become good. Systems don't do that. But today it had been made to behave, and tomorrow there were tools built to make it behave again. Ready? She asked. Always, Maya said. They turned toward the stairwell. The landing light didn't flicker anymore. Aaliyah had fixed it. Scuffed treads, ready for many more feet. Ruth's cane found the first step and tapped. Metronome, heartbeat, record. Carrying down into a house for signal, not noise. Some stories don't end with applause. They end with change. Because sometimes justice doesn't roar. It whispers through the hands of those who refuse to be erased. If this story moved you, share it. Not for clicks, but for the reminder that dignity still wins when we stand our ground. Leave a thought, a memory, a name that deserves to be remembered. And if you want to keep walking beside stories like this, stories of courage, truth, and redemption, stay with us. There's always another voice ready to be heard, and another light waiting to be seen.